All right, let's dive into the world of homeowners associations, or HOAs, where the rules can sometimes feel, well, a little murky. Today, we're unpacking a real legal case that gets to the heart of a huge question. How much transparency do you, as a homeowner, really deserve? So picture this. Your HOA board decides to spend thousands of dollars on some big new project, but you never hear a thing about it until the construction crews show up. There was no meeting, no announcement, no chance for you to say anything. The big question is, can they even do that? Let's find out. Okay, so let's set the scene. We're in an Arizona community, and the year is 2020. The pandemic has shut everything down. It was a time of, really unique challenges for everyone. And for this one HOA, it led to some, let's say, creative ways of doing business, ways that turned out to be legally pretty questionable. And this is where our story really begins. One homeowner started paying attention, and she felt like something just wasn't right. She saw these big decisions being made, money being spent, but those normal, open board meetings, they just weren't happening. Now this homeowner, Debra Morin, she didn't just complain to her neighbors. Nope. She took formal, legal action. She actually filed a petition with the state, basically claiming her HOA board was breaking the law by voting on really important stuff over email, completely shutting homeowners out of the process. And believe me, this was not a one-time thing. Just look at this timeline. It shows a really clear pattern. Between March and July, you've got pool deck repairs, appointing new committee members, a major retention basin project, hiring an architect. These are exactly the kinds of decisions homeowners expect to hear about, but in this case, it was all being approved in secret. So, you might be wondering, what did the board have to say for themselves? Well, they argued they weren't trying to be sneaky. They believed they had actually found a totally legitimate workaround to deal with the challenges of the pandemic. Their defense was actually pretty simple. They said, hey, look, because of the COVID-19 shutdown, we couldn't hold in-person meetings. It was impossible. So they looked elsewhere and found a different state law, one that applies to nonprofit corporations. And they thought that law gave them the power to make decisions using something called unanimous written consent. And here it is. You can see it plain as day, right from their own board minutes in August 2020. They officially went back and ratified all those email decisions, and they specifically pointed to that nonprofit law as their legal justification. This right here is what sets up the entire legal showdown. So what happens when it seems like two different laws could apply to the same situation? Well, you get a legal battle. On one side, you have the law that was written specifically for HOAs, and on the other, you have this more general law for all nonprofits. Okay, so this is where it gets really interesting. On the one hand, you've got the HOA open meeting law, and it couldn't be clearer. It says all meetings have to be open to the members, and any gray area has to be decided in favor of open meetings. But then, on the other hand, this nonprofit rule seems to offer a huge loophole, allowing action to be taken without a meeting at all. So, which one wins? The easiest way to think about this is with road rules. A highway has a general speed limit, right? Let's say it's 65 miles per hour. But the second you enter a school zone, a much more specific law kicks in, and that speed limit drops to, say, 15. That specific rule for the school zone always overrides the general highway rule. That's a huge principle in the legal world. So how did this all shake out in court? The case went before an administrative law judge who had to look at these two competing laws and figure out which one really applied to an HOA voting by email. And the ruling? It was decisive. The judge found that the HOA had, quote, improperly conducted association business in closed sessions via email. The decision was just crystal clear that business should have been handled in meetings that were open to all the members, period. So the judge applied that exact same school zone logic we just talked about. Yes, the general rule for nonprofits exists, but the open meeting law was written specifically for homeowners associations. That makes it the more specific and therefore controlling law. You just can't use the general rule to get around it. Now, the HOA did try to get a rehearing on a tiny technicality. The first ruling mentioned conference calls when actually the votes were all done through individual emails. But that detail didn't change a thing. The problem was the secret vote itself, not the exact technology they used to do it. The verdict stood. And the ruling came with some real financial consequences, too. While the judge decided not to hit them with a big civil penalty, given the whole pandemic situation, the HOA was ordered to pay back Debra Morin's $500 filing fee. It was a clear signal that she was in the right. Okay, so let's zoom out for a second. What does this case in Arizona really mean for everybody else? Well, it reinforces a fundamental principle of how community associations are supposed to work, and that affects millions of us. So here's what it all boils down to. First, that specific versus general rule is key. The laws written just for HOAs are almost always going to win. Second, the message is loud and clear. Boards cannot use email to vote on official business. Third, convenience, even in a global crisis, doesn't give a board a pass to ignore the law. And really, the most important point of all is that these laws are on the books for a reason, to protect your right as a homeowner to see what's going on and to participate. And that brings us to the final, really crucial question, and this one's for you. This whole case only happened because one homeowner was paying close attention. So I have to ask, do you know how your board makes its decisions? Are they operating in the open? Now you know what the law requires, and more importantly, why it matters so much.